Sunrise, Diddy. Well, yesterday, a federal high court sitting in Abuja gave a ruling restricting the CBN and its agencies from releasing monthly allocation to Rivers State. Now, there's been a build-up to all of this. But before we delve into all of that, the plaintiff, the counsel, the lawyers, they spoke. But then the governor also spoke when he got that information. So we'll have to let you listen to both of them before we come on to our guests this morning.
Issues are very clear. Let us explain in very clear terms. The section 120, 121, 122, and 123 of the Constitution clearly stipulated what should be done before the state can spend money, state expenditure. And it's clear there that no money shall be appropriated without an appropriated bill being passed by the House of Assembly. It's very clear from the judgment of Motosho, which was confirmed by the Court of Appeal, that the budget was not properly passed. And in a situation like that, if it's not passed within 6 months, a state is not supposed to collect revenue from a consolidated fund. That is the issue of lawyers. That is the extant provision of the law. And that's what the court has confirmed today, that the Rivers State government has not complied with the requirement of the Constitution on appropriation of bills for expenditures and all the things that they need to do in the state government. It's a very clear judgment. And then also looking at all the other judgments that have been passed in respect of Rivers State government, it's clear from this judgment, which also rely on the judgment of the Court of Appeal, that the state government is in violation of the extant provisions of the Constitution relating to expenditure and passing of the bill for expenditure. So it's clearly they cannot continue to allow this infraction to continue.
Okay, well, the governor also spoke. Let's hear what he said.
Journey so far, we have taken the most difficult part of this struggle. There is nothing that is happening now that is not surmountable. I want you to know that. So you need to brace up and be strong. Nothing has happened. We're still complete. We're still intact. Let me tell you, they said we're not going to last for 1 week. We're here. We have done 1 year plus. We're also doing 1 year anniversary of the attempt. Today, we have the local government chairman sitting with us. They said commissioners should resign immediately so that we'll be crippled. Today we have more than 23 commissioners. They said they are not going to do anything. We want to frustrate them in a program in USD. They said we're going to make them, they don't succeed. By the special grace of God, we have embarked on projects that are touching the life of Rivers State. So you don't need to bother about the stories that are in social media. That one is the least of your trouble. By tomorrow, I'm still going to pay my contractors. By tomorrow, those of you that have not gotten your salary, whatever salary, your alert will also get to you.
All right, so joining us to discuss these matters, we've got Shugbaye Eli, who is a lawyer and a former chairman, Degema, a local government area in Rivers State. Sitting beside him is Emmanuel Anene, who is also a legal practitioner. Gentlemen, good morning. Thank you for coming on today.
Yeah, good morning, Chamberlain.
Mr. Eli,
thanks for having me.
Good morning.
Good to see you in the studios, not virtually this time. So, tell us, what's going through your mind right now? We've heard, yes, from the governor, and probably a lot of other people may have those in government. But for you, what do you think of this judgment?
I wear two caps here. One as a Rivers man, the other as a lawyer. And that means that my constituency, the judiciary, and what's going on there should bother me. Now, it appears we're putting the cart before the horse. All of this crisis is unnecessary if we do the right things. And that's why I have the Constitution as a document that controls all persons and authorities. Once we don't pick and select what to obey or respect the Constitution, we'll have a crisis. This whole hula ball about yesterday's judgment, Again, with respect to my Lord, I'm sure all of the issues are not before her. If all of the issues are before her, judgment may not come in that direction. And what are the issues? Rivers State House has 32 seats. As we speak, fact, one representing Ahoda East Constituency 2 resigned and is current chief of staff in Government House. One, my learned friend and brother, Barrister Lulu Dinebari, died as Kana Constituency 2. 27 defected, and not only defected, took steps to show that they had left the PDP for the APC, including filing matters in court and had affidavits sworn thereto. All of that is what? Constitution says when you do that, you leave your seats. So the bottom line is, what has the government of Rivers State done, or what has Rivers Port done, or what has INEC done to fill the vacant seats? Nowhere in the Constitution does it provide for a defective member of the House not to recontest. So if we have Rivers State as a priority interest, we have Nigeria as a priority interest, this crisis will not be necessary. People simply go back and run elections because they're taking the first step that says you can't do that. And the judicial authorities. And of course, for me, yesterday judgment, I looked at it, I just shook my head and said, well, maybe the judge didn't have all the facts. But in terms of whether or not the governor can access funds from Constitutional Revenue Fund under Section 120 and 121, the law is settled. That's what somebody had passed a budget. Now, if somebody says that budget was not passed properly, they forget, and they keep citing Justice Omotoso's judgment.
Isn't that what the judgment says?
Yes, they keep citing that. And see, in law, the principle of natural justice are built on two foundations. One, fair hearing. The right to fair hearing is sacrosanct. You must hear the other side. Now, in that matter, after the president intervened, the governor withdrew. People are forgetting that.
Okay. Well, before
so when they withdrew, the judge had nothing.
So we heard your opening statement. What is your thought on this judgment?
Yeah, I'm surprised my learned friend is saying there are facts, or the fact is not complete before my Lord Justice. That's not correct. The case was contested and judgment came, meaning that the parties are aware that this particular matter is before the court. So if a matter is before the court and you're a party, you are inclined to bring all your facts that will assist the court in coming to a conclusive judgment of the matter. And that was what happened. Now, talking about the judgment, you say people kept citing Omotoso's judgment. Then, if you read section 96 of Section 1, what is the quorum of Rivers State House of Assembly to carry on legitimate business? You have to form a quorum first. If you did not form a quorum, you cannot even transact a legitimate business because you cannot put something on nothing and expect it to stand. If you read the case of McFord against UAC, Maduko against Nkemdelim, it is settled that if you are putting something on nothing, it will not stand. That Section 96 says for a House of Assembly to transact business, you must have 1/3 of all the members. Now, he said there are 32 members. Then one died and one resigned. So what is the...
And some defected.
And some defected. Now, that defection, the locus classicus in defection in Nigeria is the case of Abegunde's case. But it was decision of the court. Not somebody sitting somewhere and said, if you dig, because it's not self-executed. Even yesterday, Chamberlain, somebody, Suleiman Abubakar from Zamfara State, defected. Did he lose his seat? Late Ifeanyi Ubah defected from YPP to APC. Did he lose his seat? So it is when you go to court and canvass, because Section 109 subsection 1G that says, unless there is division in the party, is not self-executing. You have to go to court and canvass your case before the court. So the fact is not true that the facts were not before my Lord Justice that gave judgment yesterday. I think it's a victory for democracy, because we cannot live in Banana Republic where might is right, where you should speak about the judgment, because the governor was in court the other time challenging, there was a challenge to his election from Election Petition Tribunal to Supreme Court. He got judgment, unanimous judgment. That time, judiciary was not on trial. Now, like Obama said, when the case of Trevor Mattis came, he said, we're a nation of jury. The law has spoken, and we don't have any alternative than to abide by it. If you go to court and you lost, then you have the window to appeal. If you go to Supreme Court, you cannot appeal again. But it is not good for the governor, for any other person speaking on his behalf, to continue to downgrade our judiciary because the judgment is not going your own way. Because what is happening here is, because if you read the case of Williams against Magic Kodemi, it was decided in 1962. The Supreme Court says if a legislator oversteps his bound oversteps his bound or did not follow the due process required by the Constitution, that step is nullified. Then if you read, there are also a locus classicus on this revenue case in Nigeria. The case of Attorney General of the Attorney General of Bende State and Attorney General of the Federation. It was decided in 1982. What did the Supreme Court say? What happened was that the National Assembly constituted a joint committee. The joint committee passed a resolution about that allocation bill. What they did was to adopt it without going to different houses to re-adopt it. And so the Supreme Court said no. That becomes a nullity. Okay. So also the 2024 appropriation bill passed by Rivers State by 3 members.
Okay, so
it is ridiculous.
If you could just, I'd like to get your response specifically on this. The question of quorum, and then the examples that he's given about those who defected in the same country and didn't lose their seats.
Let me just say this again for emphasis. I said I sit down here with 2 caps.
Yeah.
I don't want to be misunderstood. My learned friend has cited laws. Well, in the courtroom, but okay, it's okay. Now, in law, if a court, even if a judge were present in the scene of crime, all right, it's incumbent on the prosecution to prove this case. Basic principle. The judge does not need to tell the world that I saw it. No. That's how the justice system works. We're saying that the parties come to court to facts. And what are the facts? Except we're thinking Nigerians are dummies. People see what's going on in Rivers State. Now, if a court, properly so called, sees the jurisdiction, sits on a matter, the facts are known to the public, and the judge returns a verdict.
But the facts are not, the court of public opinion doesn't determine.
And I'm not saying it determines. Justice must be seen to be done. Seen to be done by who? By the justice system, and seen by who? The public.
So clearly you don't think justice has been done.
I'm coming. For me, what's important for also put integrity of judiciary, and I think it's the fact that I try to use the word that I'm trying to denigrate. I'm not. As a lawyer, senior lawyers have said this. What I'm running away from? A matter arose from a family house, same political party. Somebody has taken a step, and he has cited examples of what the judiciary has done, local classicals. He forgets that the Supreme Court has spoken in the case of Michael Dapelong against Joshua Shibidari, when part-time members of the House Assembly of Plateau defected, all right, to join Advanced Congress of Democracy, ACD, from the PDP. Now they came back, those who are remaining, attempted to impeach the governor. The Supreme Court, speaking through my Lord, the Honorable Justice Walter Kanu Onogen, former CJ, said, look, all of what has happened is when there's a depletion in numbers, the House can sit. Where there's a defection, what you cannot do is a power to impeach the governor. That's the power they can exercise. So applying that to what has happened in Rivers State, except by saying that the federal court is not bound by the decision of the Supreme Court, that's a defection. And you want to answer the question, if it does right, why are we not having denials about defection? You trade the cause,
so for you, the status of, you're saying that the defection subsists.
It subsists, and I take exception to the fact that it says it must go to courts before.
But isn't there a judgment?
I'm coming. We have the situation where if the presiding officer is not a victim or is not guilty as well, as we have in Rivers State, you cannot be a judge in your own case. In any event, people also forget that at the time that thing happened on December 11, by December 13, the High Court of Rivers State sat and gave approval to FHC here to sit as Speaker. And as Speaker, he wrote a letter to INEC after he executed that provision of the law, Section 109, Sub 2, gave effect to that defection and called for INEC to conduct election to fill those seats.
Was it validly elected as Speaker?
A court has said so. I cannot sit on appeal against that court. I said the High Court of Rivers State, presented by Justice Bonima W. Danagogo of High Court of Rivers State, said so. I'm not in the position to review that judgment. I can't sit on appeal that judgment. Now, he sat on that and gave that order. Now, the question is, in law, what happens when you have a judgment before you? Only 2 things. You have only 2 options. One, you obey the judgment, or you appeal against it. You have no third option. So when that thing happened, those who are questioning what has happened, the question is, what did they do with that judgment? And why has INEC not obeyed that letter?
I want to get Mr. Nene's thoughts, because, you know, many reactions have trailed these judgments. I want to give you the one from CISLAC yesterday. And I want to be able to quote them. So Nigeria's states are vital components of our constitutional framework, led by elected governors charged with managing resources for the benefit of the citizens. Blocking allocations not only undermines this autonomy, but sets a dangerous precedent, risking destabilization and endangering regions currently at peace. What do you make of those statements there by Sislak?
I'm a lawyer. That's my primary constituency. Whether Sislak are politicians or not, I'm not aware. Or, all these organized civil society groups. Let's discuss law first. If we discuss law, this is the provisions of the extant law. This is what I've cited the case of Attorney General of the State against the Supreme Court nullified, even though that was a Federal Appropriation Act. Now, the court in this instance...
Bender State?
Yes.
Okay.
AG Bender State. That was a locus classicus on this appropriation case in Nigeria.
Okay. It
was decided in 1982. If you can read it. One constitutional law report, 430. You can cite it. Now, the court has spoken that this is because why we are, like Obama said, we're a nation of laws. And the court is that if you have misgiving against any judgment or anything, you approach the court for resolution. And what the court says becomes the law. Now, the court says 3 people cannot sit down in the comfort of their room and pass a budget of a state. Now, it's not anybody, unlike what happened during Obasanjo's regime, when our president was the governor of Lagos State. Obasanjo unilaterally stopped the allocation to Lagos State. But that was overturned by the Supreme Court. In this case, it is only the court that has right to stop such allocation, and the court has done it. The court did not just stop it. It said, represent 2024 River State Appropriation Bill to the appropriate authority. And what is the appropriate authority? The appropriate authority means the House, eminently led by Honorable Martins Amehule. That was recognized by Justice Omotosho's case. That was recognized by Justice Peter Lifu's case. That was also recognized by Court of Appeal decision. Now, the judgment is cited in Port Harcourt or interlocutory applications. They are not final judgment. And in this case, interlocutory applications cannot be played side by side with the final judgment, because as at the time you are giving interlocutory order, you have not been able to have a clear view of all the matters. It's when you give a final judgment, you would have considered all the issues vis-a-vis the facts before you. Now, he's talking about fair hearing. Now, in that Justice Omotosho's case, the governor is not the plaintiff in that matter. The people who are the plaintiff in that matter is River State House of Assembly and Martins Amehule, the second plaintiff. The governor appeared there as 11th defendant. Then the Attorney General was also there. Now, the Edison here was the 17th defendant in that suit. For reasons best known to the governor, he withdrew all his applications. And my Justice Omotosho made allusion to that. In that judgment, he said it should be noted that the 11th defendant in this case withdrew all his applications, including the filings he made in this case. There was no reason given by it, and I'm not here to give any reasons. If the president said withdraw all your cases, now the president is directing you as a plaintiff, not you as a defendant, because you are not the person that instituted the matter. If the person that instituted the matter has refused or failed to withdraw the matter, you as a defendant, you don't have a right to, unless you don't want to defend the matter. And that was what happened. And in this case, the governor can no longer plead lack of fair hearing. And that was what played out in Court of Appeal. When the judgment of Omotosho came, he went to Court of Appeal to challenge it. Now the Court of Appeal said, in the trial court, you withdrew your processes voluntarily. Why are you coming to challenge it before the Court of Appeal?
Let's talk about the response of the governor, because we did hear him say this is not...
Can I come in?
Hold on, we'll get to you shortly. The governor says this is not my problem. This is not one of my pressing issues right now. I'm even going to pay my contractors today. People that haven't gotten their alerts are going to get their alerts recently. You know, should he be worried? Is this something he should be worried about?
The governor should be worried, because the governor should be worried, and every Nigerian should be worried, because that is what the governor, maybe he has sold himself to impunity. Because the Court of Appeal even use it, because he has immunity, he can do anything that he likes against the extant provisions of the 1999 Constitution and extant laws. The judgment of if it's in America, a court give a judgment, even the president should be worried. Everybody should be worried. We cannot be denigrating the judgment coming from court because it does not concern you or you have the power to overreach it. The governor should be worried, and he should obey the court order. There are 1, 2, 3 asserted judgment of Peter Lifu, asserted judgment of Omotosho. Don't present any budget except the one led by Martin Sambehule. Don't present anything to the so-called, the court uses so-called 3 members House of Assembly. The governor ignored it. He has been treating the court judgment with levity.
All right.
Mr. Shagbe.
It's unfortunate my brother is enervated. I don't know where he gets his energy from. He does not remember that the Supreme Court that rules in that Dapelon's case. And that judge that he's referring to is bound, including Justice Lifu. He has also not had his mind to the reason why Milord, the CJN, had set up a panel to look at these conflicting issues in River State. If it was normal law and everything was okay, you think the CJN would do that? That should give me some kind of red flag. All is not well. The courts exist to do justice, not to play and pander the whims of caprices of politicians. We can't submit a lot of politics.
I want to get your thoughts on the complaint, which is that, this is it's undermining the sovereignty of a state.
Of course.
So you agree with Sislak?
Of course I agree with Sislak, and not only Sislak. If you apply the Supreme Court judgment in the case of Attorney General of Lagos State against Attorney General of Federation in 2004, when President Obasanjo seized Lagos Council funds, because then Governor Bola Ahmed Tinubu, leading Lagos State, created councils. Now, the Constitution says for you to create a council in your state, you must bring the National Assembly for concurrence, for approval. So if you don't do that, the council inchoates. That's the word the Constitution used, the Supreme Court used. Now, be that as it may, the president then ultra-vires the Constitution, sees the allocation going to Lagos. So you have 20 councils, must stay there. May Lord the Honorable Justice Mohammed Lawal Louis led the panel and rules and said, release it. The council's money is going to sub-national units for any reason. So here we are, whether you began by the president seizing the allocation on its own volition, so motu, or whether a court sat and seized it because a matter of president of the court, it's ultra-vires the Constitution. What are the issues? Why are we running away from the defection issue?
I'm sorry, are you saying that this judgment is ultra-vires to the Constitution?
I'm saying so because in our system, in our legal system, in the hierarchy of courts, whatever the Supreme Court has said is binding and final courts below, when the principles are the same. When the principles are the same.
What's the principle?
The principles are not the same.
I'm coming.
You'll come to that.
The principle of withdrawal allocation. For any reason. In the case of Lagos State, the governor, the Lagos State government did not complete the process of creating local government council. Therefore, the president probably was not patient enough. In this case, the president is not a party, but some people in River State have gone to court to say, look, now those who come to equity must come clean hands. Who took this matter to court? Who sued the River State Assembly?
No, but those are different principles.
I'm coming.
Trying to create a local government.
No, I'm coming. I'm saying the principle of season allocation. Okay. Someone has the power to hold power, right? Say, don't give this. All right? Whether how you exercise, whether you pass through a president or you pass through a court. But simply saying the principle is you're withholding money that is due to subnational units. All right? Now I'm saying that, look, we have to tread softly. You come to equity with unclean hands, expect that equity will give you what you want? No. Somebody sued the House Assembly River State. After he defected, Pastor Mehule read out his defection letters. Citing Section 109 sub 1G. It was also a court that told him, he said it. He read the letter himself, who gave him. Now you know obey the same constitution. You talk about 96 as quorum. Quorum talks about the members of the House Assembly. Now, so if we have a defection, as a Rivers man, I'm concerned that we're not filling those vacancies.
Okay.
It must not be by you.
Yeah, I hope you don't lose your train of thought, but let me ask you too. So, yeah, you've spoken about the principle, which you'll respond to in a minute, but can you also speak to the fact that why the plaintiff, the governor and Edison here were said to have withdrawn their cases? So having withdrawn all of those things to the courts and Justice Omotosho gave his judgment, why were they then appealing? On what grounds were they appealing when you withdrew all of it?
If your matter is in court, even a legal system recognize what they call alternative dispute resolution. So people can be in courts, even in battles where people are fighting as soldiers. They go to the side and speak. It's done so many times. So while this matter was raging in university, the president intervened. Maybe forget the facts. Let's not forget them. An advice party, if you look at that 8-point directive by the president, one of the parties must withdraw all suits and discontinue litigation. What we're asking is, so Governor Hobara withdrew, even though it was the defendant. Edson withdrew, even though it was the defendant. And then the plaintiff failed to withdraw. And now the plaintiff is now lashing on that.
So two things. In that case, well, maybe they were trying to get a solution, so he withdrew. But people will also ask, but if the plaintiff didn't withdraw and the defendants withdrew, shouldn't you have asked questions or make public outcry? Look, this has happened, this person hasn't done it. And two, after that happened and the judgment was given, why then were you going to appeal after you, according to judgment, you shot yourself in the foot?
I agree with you. See, in law, if I withdraw from a process and the judgment comes and the judgment affects me adversely, I have a right to appeal. What you do in law is that you seek leave to appeal. And seeking leave to appeal, that kind of special judgment, you give advanced reasons why you should be heard. All right? Maybe the appeal court was not convinced enough by the reason adduced by the governor in filing his appeal against a consent judgment. But a moral question has arisen here. And whether people like it or not, some school of thought in law say law and morality don't mix.
Say laws
but
are
they
about
do mix. For me, I believe the school of thought I do. I agree that, for instance, if a man walks into my home and at gunpoint robs my family, maybe rapes my daughter, and then runs out, and then hides under the toga of one kind of order of court to protect him, or maybe has immunity. Yes, that's all the law says. But am I satisfied that I'm unable to go after the person that did that kind of thing to me?
But you can't take laws into your hands.
That's what I'm saying. So let's say I can balance the two sides.
Okay.
If the governor had, for instance, in good faith, withdrawn his process, and that party also withdrew their process, will not be here. Now, you that did not withdraw, it's acting like you're wise enough to have done what you have done. What about the fact that you defected?
We're going to come to quorum, but go ahead and respond before we go to that
you
part.
see, let me make the matter straight. Edison here did not withdraw any process. Edison here resigned his membership of Rivers State Assembly, and it was noted in that judgment.
Yeah, but the part that he said was, even though he says interlocutory, the court recognized him as speaker.
Yes, now, but in the court recognized he resigned. He's no longer a member, so he has no locus standi again. To even say anything. No. Once he resigned, once the matter was pending,
yes,
and he voluntarily resigned his membership of Rivers State House of Assembly. So he has no locus in that case.
No,
because
is that resignation valid from the point of law?
No, the resignation of his membership of that house. Because it's that house. You have to be a member of a house before you become a speaker or not a speaker. Now, when he resigned his membership voluntarily to take another appointment as chief of staff, he has lost his locus standi in that case before Justice Omotosho. That was what happened. Now, talking about what he said that the CGN invited the court about the judgment's comment. If you read section 272, subsection 3 of 1999 Constitution, the State High Court, where they got that interlocutory order, does not have jurisdiction to determine whether a member has lost his seat or not. The jurisdiction, it was exclusive jurisdiction engraved to the Federal High Court to decide whether a governor...
Even though it's a state matter?
No, that is the Constitution that is talking, not me. The Constitution section 272, subsection 3 says the state.
Hold on, just so you can.
I'm coming. I have to respond to many things he said now.
Okay, but the thing is, because I don't want him to lose his train of thought, because he doesn't agree with that. And
it's not about
many people do not agree with that.
You will read the Constitution.
Okay.
Section 272, subsection 3 of 1999 Constitution gives exclusive jurisdiction as to whether a person has lost his seat as a member of State House Assembly or a governor or deputy governor exclusively to the Federal High Court.
Okay.
The State High Court has no jurisdiction, but they ran to State High Court in Rivers State to get an order. And that is what we are contending here. Now, if you think about what he was talking about, morality or no morality, if somebody filed an action, instituted an action, and the directive came from Mr. President, the persons who are in court, who instituted actions should withdraw, who instituted actions. If he did not institute an action, how are you going to withdraw what he did not institute? So probably the governor was misled, or he had other games that he was playing in his mind.
So
because the reasons, if you are going to withdraw your process, you obviously state the reasons. He didn't say that he was withdrawn because Mr. President advised them to withdraw their processes.
Yes. Go on.
First, let me disagree with him with respect. Section 272, sub 3 has been misinterpreted severally by many people. The impression they give is that suddenly, by the amendment of that constitution, federal courts are now superior to state high courts. It's a court of coordinated jurisdiction, for God's sake. And the issue, the subject matter, the course of action is a state. I was in the states. Now, that section of the law talks about vacancies, not talking about defections. Vacancies could arise by resignation. It could come by death. All right?
So if you lose your seat,
272 does not override the 109 on the issue of defection. That's two different things. So when the High Court of University sat down on that matter, it doesn't act out of jurisdiction. If you go to 109, that's what the court dealt with. The court didn't go to 272. They're the ones that are dragging 272 into the matter.
No, excuse me, you are mixing. I'm not. Section 109 1G says if you defect and there's no division in your party, you have lost your seat. Now, Section 272 now tells you what to do in this circumstance. The appropriate court to go to determine whether somebody has validly lost his seat or not. And they ran to a court that has no jurisdiction.
The word defection is not there in 272.
No, it's not about defection. It's
vacancy for the right of death,
determine whether somebody
resignation.
No,
otherwise,
counsel, don't put words into my mouth. It is the Federal High Court that decides whether somebody has lost his seat or his seat has become vacant. Because if somebody has defected according to you and he lost his seat by virtue of that action has become vacant. I don't know why you are playing with the words here.
Well, Chamberlain is going to get that thing.
Well, which one? There are many, of course.
No, what I'm saying is it's Section 109. Section 109 says if there is a defection in your party.
Okay, so CC 109, and correct it. I hope
109 1G.
109 1G. No, 109 1A first says a member of a House of Assembly shall vacate his seat in the House if G then says being a person whose election to the House of Assembly was sponsored by a political party, he becomes a member of another political party before the expiration of the period for which the House was elected. So he is saying shall there means it's self-execution.
Provided.
Shall.
You understand? There is no provided there is no dispute in that. That's the fact. Because like I told you, the member defected even yesterday. The Speaker of House of Representatives read out his letter. I told you about Ifanyoba. I told you about in Enugu State where I come from. 6 members of Labour Party left Labour Party for PDP.
Okay.
Now if you read now Section 109 said, if somebody defects, he will lose his seat. But the court that will determine whether his seat has become vacant, the exclusive jurisdiction goes to the Federal High Court. And so also if you read Section 251 of 1999 Constitution, even though the State High Court and the Federal High Court are par, but there are in some cases exclusive jurisdictions were given to different courts. And once it is stated by the Constitution, there's no interpretation anybody can give to it.
So, Mr. Eli, what he's saying, perhaps if I understand what he's saying, you say self-executory, he says not. He says it's not. So, do you think that there are probably, well, yes, condition precedent and subsequent before this session can apply?
No, the Constitution did say so. Okay. Now, people go to court only when there are issues, when there's a dispute. Yeah. Was anybody disputing with Ameul and Co. about defection? They voluntarily read it on the floor. And in the House of Assembly, even if they cough while they're speaking, the Hansards capture it. The Hansards are the reports, verbatim reports of what happens in Assembly.
So 2 things, if I could ask you. If they say it, does it automatically mean that what they say has complied with the laws? Can't I come out and say, well, this has happened? Now my party says, no, I don't agree with you. This is not happening in my party.
No, see, if we follow the laws of the land strictly, if you go to Section 1 of the Constitution, it declares without ambiguity that its provisions are binding on all persons and authorities. So it's not about what I can say in the morning, come back and say in the afternoon. No. The laws allow me to equivocate or do as I please. Whether I'm an individual or a channel television, they can't do that. Once you take a step on an issue, we'll hold you to account on that step. Not only did they declare on the floor of the Assembly, they took steps. It is when they realized, oh, there are consequences for this recklessness. They are not backtracking. That should give us a red flag.
Okay, now, so do you have any decision of the court that validates that, look, these chaps have defected and this judgment subsists?
Shemal, I'm saying that people...
Because there's a dispute now about this.
No, there's no dispute. They are the ones.
You are saying that they have. They are saying they haven't.
No, they are the ones. Remember, look at the sequence. On the 11th of December, they announced openly that they've left the party. By the 13th of December, a High Court sat in Rivers State via an interim order, right? And that's how it came to the picture. Then there was a member that had not resigned from the House. As Speaker, he gave effect to 109 sub 2. Read. So if he cites an example where some people defected and the Speaker, who is presiding, refused to give effects, that's not...
So can the process be said to have been complete if the Speaker who decided doesn't give effect?
If the speaker which presiding does not give effect, if the speaker does not give effect, does not mean that the law has been set aside. Don't forget that, look.
But is the process complete?
No, listen. There are two different things. Let me situate this very well so you understand. In the case of Rivers State, the speaker that had done that himself when it happened on the 11th of December is also involved. So you cannot be a judge in your own case. No more judex in Kosasoa.
So there was no speaker at that time?
At that time, that 11th, there was no speaker. But by the 13th of December, there's a speaker, backed by law. It says an interim order, but at that moment, that's the law. That's the judgment of the court.
No.
Excuse me. Sorry, let me finish. After 13th December, that was the law. Whether you call it interlocutory or not, it's immaterial. At the time you sat in the speaker's chair and gave effect to 109(2), that was the law.
Okay, so what about what he says that having resigned, you lost your position as speaker?
That's an effect. That's an aftermath. He has left the seat. That does not nullify what he has done. Look, Celeste Mayor was governor of Rivers State from May 29, 2007, until the Supreme Court knocked him off October 25, 2007, when Richard Meji took over October 26. That did not invalidate the acts, including the assembly that
so
they
the
proclaimed.
Office is deemed to have taken that decision.
Of course.
Okay, quick response.
No, it's not true. It's not true. Now, he said as at 11th, there was no speaker.
No, I didn't say so. I said at the 11th, there was a defection. Maybe they started the speaker chair and read the letters.
He said he did it on 13th. That was what he said.
No, now you don't get the argument here, sir.
So when was the pronouncement made by Edison?
Now listen again. On the 11th of December, at plenary, Martin Chika Megule read our letters. We had the video on channels everywhere. On the 13th, a High Court of Rivers State sat down and gave an ex parte order granting Edson here.
Ex parte?
Yes, motion party.
No, the court in this case. So what I'm saying is that the court appointed Edison here.
You can accept the court appointed Amechi governor in 2007.
Is that what I'm saying?
Yes.
No, now what was saying is
hold on, sir.
As at the time,
ask a question. Let me land.
Okay, let him just land.
No, let me
respond.
Ask a question. Let me land.
As at the time.
No, you're going to come in immediately you finish it. Finish quickly so you respond.
Yes. At the time, the courts exist as moderators. All right? When things happen between arms of government, between the court step in. You could as well say the court appointed Amici as governor, right? In 2007, because he didn't participate in the general elections. The court can intervene and make a man a woman. It's as a lie, no sir.
Hold on a second.
No, I'm not holding on now. Let me also open my mind. I'm not holding on. Now, what I'm saying is this. What I'm saying is this. As at the time this man was made a speaker by the court, according to him, he did not form a quorum. According to section 96 of section 1, what the constitution says, if you did not form a quorum, you are adjourned. He didn't tell anybody to be to and appoint a speaker.
What is the defection?
The defection, the defection came on 11th.
Yes.
But as at the 13th, he went to SAT. They didn't form a quorum to transact any business.
The reinstated APC chairman in the state, Emeka Beke, he's confirmed that they are members of his party and that he's in possession of their membership cards.
That's why I'm saying the question of defection is a question of facts, not a question of law. Because all these facts should come before the court, who should not sit down to know whether the condition stated in section 109 subsection G has been infiltrated or not. If the court is of the opinion that these people have defected, they will declare the seat vacant, as the court did in Abengude's case. It's not somebody sitting somewhere that declared the seat of Abengude vacant. It was court. And in this case, what we're saying is that if they are led to believe that 25 others, now 27, have defected from PDP to APC, they then go to court with all these facts they are talking here. The court will look into the facts and give a verdict. Because the governor, the governor has been consistently disobeying court order that are not in tune with him. Now, I cited judgment of Omotosho, I cited judgment of Peter Lifu, I cited court of Abi judgment, I cited the judgment of yesterday. That the governor is saying it doesn't matter. I mean, it would be an injustice to the people of Rivers State. I mean, the legal conversations and the debates about it, they're very important for clarity and understanding. But these funds are supposed to go to the local governments. They're supposed to be able to help the people. We would not be doing justice to this conversation if we do not talk about the impact that this thing is going to have. No, the people should not. The people should not approach the government and tell him to do the right thing, because we're in democracy. Democracy is guided by rules. There are rules of engagement in democracy. It's only in military government that might is right. So the people should approach the governor? The people should approach the governor. The people that elected the governor, they should approach the governor to say, hey, Mr. Governor, please obey the court judgment. There are 4 judgments that are pending before you. Please give effect to that judgment and move on. So, the court did not say don't give for. He said represent this. Let me ask you. Represent this 2022 appropriation bill to the appropriate.
Again, if I understand what he's saying that look. So, or maybe I should also ask: If the governor then says, well, maybe in the interest of the people of the states, because look, the state cannot come to a halt. Business must go on. If he then says, well, of course, we're not happy with this judgment. The people, at least if the people say, we're not happy with this judgment, I'll present this budget. Of course, they can't reject. I don't know if they'll reject it, but if they pass the budget and then he then subsequently says, I'm going to appeal this case, what would have gone wrong?
No, see, we will not make a mistake twice. We just had an example where the governor withdrew on the strength of the president.
Yeah.
Okay.
And then the other parties run away with victory. Now, when he says here that the governor is disobeying God orders, I take strong exception to that. You're misrepresenting facts. The governor acts on laws. When these judgments are given, as I speak to you, people file motions for stay, all right? Execution. People go ahead and appeal. That last matter is for the Supreme Court.
These are
excuse me. Now, until the Supreme Court determines an issue, you can't come around and help the source of self-help. So if the governor, while he's waiting for the Supreme Court to speak on that issue, all right, one of those matters that the appeal court ruled that's in their disfavor is before the Supreme Court, right? Well, Okojumbo is speaker. Listen. If the Supreme Court says no, go back. Then you cannot come back here and see the judgment and say, Governor, go and comply. While the governor has gone on appeal, the governor cannot approbate. He cannot be on appeal and then go back and present the budget. Now, what are they asking for? I said a court comes to a finding of facts when all the facts are before the judge. All right? Mm-hmm. The issue of defection has not been determined by any judge. There's no time in all of this that a court sat and somebody was put in the witness box to now prove evidence of defection and that the person failed to prove before the court. So when that kind of thing, now everybody's lashing on Motor's judgment because that's where this crime is coming from. Well, after the party had withdrawn, that had the counter-affidavit to show that you defected, had withdrawn. There was something before the judge, all right? So lashing on that is not doing justice to the case.
So, gentlemen, willing to wrap up. You got a question?
I mean, there isn't time.
No, I had a
30 seconds. 30 seconds.
No, what I'm
just
saying,
wrap up in a few seconds.
According to him, he said the issue of defection has not been decided.
Yes.
If the issue of defection has not been decided, that 27 lawmakers remain the members of the Assembly.
Hold on.
See, that is the position of the law. And the law, our constitution cannot allow 3 members, according to the judgment of a motor, so-called members to sit down, pass appropriation bill, screen commissioners, and do certain correspondence with the governor. It is invalid.
Yes. The Dapalong and Darius case come for the Supreme Court. The court say no, those members can sit. The section 102, read section 102 of the Constitution.
Until it gets to Supreme Court.
Hold on.
Answer the question.
No, he said no court has done it. In this case, the Dapalong case is saying
anybody call
the Dapalong case is saying it's a decision of the Supreme Court, not a statement from the governor of
the governor filed a suit in court.
It is still the rule of law, whichever way, not the rule of law. So they both know that, well, if a judgment is there, you have to appeal. And if you get a stay, it stays until that matter is adjudicated upon and decided.
Declaratory judgments are not stayable. You don't stay declaratory judgment. It is immediately implemented upon pronouncement.
I'm talking about
These words are declaratory judgment. You don't stay it.
Shogba Eli is a lawyer,
state does not
former chairman, Degame local government area in River State, and Emmanuel Anyane, legal practitioner. Gentlemen, thank you both for coming on this morning.
Thank you for having us.
Business Morning comes up now.